What are the chances of winning a domestic violence case on Long Island? In the U.S., there is a rising call for domestic violence cases to be taken seriously, and lawmakers and law enforcement have heeded it by taking accusations of domestic violence seriously. For vulnerable victims, this is a positive outcome, but those falsely accused can face serious implications. Facing a domestic violence case can be one of the most stressful experiences a person can have. Aside from criminal proceedings and the prospect of conviction and the accompanying penalties, dealing with orders of protection from your own family and not being able to access your family home can be emotionally draining. Any legal case can be demanding, but even more so when one's family is involved. Domestic violence charges on Long Island, New York. Domestic violence in New York is an umbrella term for offenses and criminal acts that occur between individuals who have a relationship, either social, romantic, or familial. The definition can extend to include those who have been living in the same household for a period of time, or those who were in an intimate relationship even if the relationship has ended. While discussing the matter of domestic violence, it is important to remember that domestic violence and abuse in this context do not only apply to physical abuse but also to abuse such as psychological, emotional, sexual, and financial abuse. Charges falling under the category of domestic violence can either be a misdemeanor or a felony depending on the criminal act committed. Domestic violence can involve the following charges in New York. 1. Disorderly conduct. 2. Sexual misconduct. 3. Sexual abuse. 4. Forcible touching. 5. Rape. 6. Assault. 7. Reckless endangerment. 8. Harassment. 9. Stalking. 10. Menacing. 11. Strangulation. 12. Criminal mischief. 13. Intimidation. 14. Identity theft. 15. Grand larceny. 16. Coercion. 17. Murder. How are domestic violence cases concluded? Domestic violence cases can vary greatly in the ways that they are concluded, especially since each charge can be vastly different from the next. The time it would take to conclude a case would be affected by how much backlog the court has and whether there are mitigating or aggravating factors in the case. Even taking these facts into consideration, domestic violence cases that conclude with a trial only occur seldomly. One of the most important things in a domestic violence case is never to violate a protective order. While waiting for the case to be heard, the court may issue an order of protection that prohibits the defendant from making contact with the victim. During this time and while the order of protection is in place, it is crucial to exercise patience, as a violation of a protective order can result in additional charges which can damage your defense. Building a strong legal defense. There are some defenses an attorney can use depending on the facts and existing evidence of the case. While the zeal with which prosecutors try domestic violence charges is understandable, they would not want to waste the court's time pursuing false claims. The court may be more willing to dismiss domestic violence cases due to the following reasons. 1. History of false accusations. The court will investigate if the accuser has a history of sending false claims, and this can weaken the prosecution due to the possible lack of credibility of the accuser. 2. Lack of supporting evidence. If there is no evidence of the defendant's guilt, the prosecution may dismiss the charges due to the burden of proof. 3. Lack of cooperation from the accuser. The accuser in a domestic violence case serves as a valuable witness. 3. If the accuser takes their statement back or refuses to follow the prosecution's instructions, the prosecution may be forced to dismiss the charges if there is a lack of other evidence. 4. Mistaken reports. Concerned neighbors and friends sometimes report a domestic violence case that proves to be a misunderstanding in the end. 4. In this case, the prosecution may dismiss the charges due to a lack of basis. 5. Injuries inflicted on the accuser were due to self-defense. In some cases, the accuser would be the one inflicting abuse on the defendant in the hopes they retaliate. 5. When the defendant acts in self-defense and is taken into custody, a medical inspection of the accuser and the defendant's injuries can reveal whether the defendant was acting in self-defense. Contradicting evidence. If eyewitnesses or witnesses who have no standing relationship with either party submits evidence or testimony contradicting key elements of the case, such as the accuser being the perpetrator of the domestic violence or that the report was a false claim, it can contribute towards building a legal defense in favor of dismissing the case. A Long Island domestic violence attorney may be able to gather evidence on your behalf and champion your interests in court. While your case is ongoing, it is crucial to follow your attorney's advice to avoid any complications that may jeopardize your chances of getting the best possible outcome for your case. At the offices of Jason Bassett Criminal Attorney, top-rated Long Island criminal defense attorney Jason Bassett leverages his years of experience to carefully investigate each case and provide a tailored legal defense to clients. We leave no stone unturned in gathering the necessary legal evidence that may help achieve a favorable outcome. Criminal attorney Jason Bassett provides aggressive legal representation to Long Island residents who have been accused of a crime. Contact our office today at 631-259-6060 to schedule a free consultation.